Guardianships for Adults by John P.L.L.C, Esquire. What you need to know. Hello, everybody. My name is John P.L.L.C. I'm an attorney with the West Palm Beach, Florida Law Office of P.L.L.C Hauser. We're located in downtown West Palm Beach, Florida, and we handle trials, disputes, and appeals of probate and commercial litigation matters. For the next 40 minutes, I'm going to be speaking to you about guardianships for adults, not guardianships for minors, but guardianships for adults, and why contested guardianships are one of the biggest leading trends or recent developments in the evolving law. We're going to talk a little bit about why guardianships for adults are on the rise, and particularly why they're so hotly litigated or contested. This webinar is brought to you by P.L.L.C Hauser. It's free of charge. We're on the web at www.pklskilawfirm.com or phflorida.com. This is one of many webinars that we offer free of charge on a host of Florida probate litigation topics, and we invite you to attend other future webinars, as well as looking for the text and audio, as well as the slideshow on iTunes, Facebook, and other parts of the web. So I'm going to be speaking to you today about guardianship for adults. We're going to cover a number of topics very quickly, but I also wanted to let Florida attorneys know that in December of 2016 and for all of 2017, we'll be offering free continuing legal education credits for ethics, for your ethics requirements. We'll be offering 3 full hours of ethics credit for the Florida Bar. If you're a member of the Florida Bar and you need ethics credits, we invite you to join us on that webinar or those 2 webinars that'll get you those credits. You can email Amanda at phflorida.com. That's Amanda Phillips. She's at extension 101. Our phone number is 561-514-0900. Email Amanda at P as in P.L.L.C, H as in Hauser, Florida.com. With that said, let's get into the topic of guardianship for adults. I'm going to be speaking to you about 5 discussion topics today. The 5 discussion topics begin with, what is a guardianship? We're going to be talking about that for about 10 minutes. And then we're going to talk about, how do you file a guardianship? What does that mean? What's the difference between a petition and a complaint? We're going to talk about who can get involved, the very important issue of legal standing, and who can be involved in a guardianship matter, and can anybody be involved in a guardianship matter? The next thing we'll talk about is what happens when you file for guardianship. A whole bunch of things occur. Things get set into motion. There are a number of legal actors who will appear on the scene. And you need to understand what their role is, who they are, and why they're there. We're going to talk about the X factor in probate litigation, and guardianship is no exception. We're going to talk about attorney's fees. And specifically, we're going to talk about who pays for attorney's fees. And then finally, what happens if there's a power of attorney or a POA. So with that said, I've got 2 introductory remarks before we get into what is a guardianship, our first substantive topic for today. And the first topic is the background. We're talking about a guardianship of an adult, an adult person who may be partly or totally incapacitated, or may be partly or partially or entirely incompetent. And what that means is that adult person cannot or is incapable of making certain decisions for himself or herself, may be incapable of managing some or all of his or her property, and may need assistance and protection. That's what we're speaking about, an adult, not a minor, although we know we have guardians and guardians ad litem all the time for minors, particularly in lawsuits, but we're speaking about an adult. Many times as we age, our bodies are just fine, and so objectively we look like we have it. But the truth is that mentally we may be declining, whether it's from Alzheimer's, old age, dementia. As we slow down, we may need more protection and assistance. And so guardianship law is a hotly developing area of the law. The number of guardianship cases seem to be rising. Certainly the number of contested or litigated guardianship cases is on the rise. And we're seeing the body of law of guardianship, particularly in Florida, where we have a large elderly population, developing over time. We handle trials and appeals and disputes of all probate, estate, trust, and guardianship matters. If you asked me 10 years ago if I was a guardianship attorney, I'd say no. Now, every day we're working on guardianship cases in Florida, and our law firm has a very vibrant, very healthy guardianship practice trying to assist family members who are dealing with a parent or a loved one or a relative who may need some protection, may need a guardianship from a local probate court. The other issue that seems to be present is this massive wealth shift. The Boston College Center of Wealth and Philanthropy estimates that $56 trillion is being passed from the World War II generation to future generations, Gen X, Gen Y, the millennials, right now and over the next couple of decades. This is the largest transfer of wealth in the history of the world, in the history of humankind, and everyone seems to be fighting over it, right? The old way of doing business was that you didn't fight over your parents' estate or their money until they passed away. But that's not happening anymore. People are instituting guardianships, filing for guardianships right now while mom and dad are still alive, and they're questioning their marriage, their estate plan, what their will and trust say, who's managing their money, and who's dealing with their money. We're particularly seeing a large trend, a growing trend of contested or litigated guardianships between a second or third spouse, the present spouse of an elderly person in Florida, and their adult children from a prior relationship, a stepmom versus a stepson or a stepdaughter or vice versa. Okay, so with that background, let's get right into it and talk about what is a guardianship. We're going to spend about 10 minutes on this, and we're going to try to give you as concise of an overview as we can. This seminar, although it appears to be advanced in its level or its nature, is intended for the layman, the layperson, as well as paralegals and attorneys who are looking for an introduction to guardianship law. So a guardianship has been defined as a legal proceeding in the circuit courts of Florida, what others might call the superior courts, in which a guardian is appointed, maybe, maybe not, to exercise the legal rights of an incapacitated person, right? That's right out of the Florida bar, okay? So we're talking about a legal proceeding. It's in the probate division down here in Florida. The courts have many divisions in Florida. They have a juvenile division, a criminal division, a trial division, a family law division, and the probate division handles all trusts, estates, guardianships, and probate matters. So that's what we're talking about. And you need to know your probate code, right? Everything starts with the probate code. Really, really important. And you'll be hearing a lot about Chapter 744. That's the guardianship code. That's the section of the Florida probate code that deals with guardianships. So again, we're talking about adults. We're not talking about minors, right? And we're talking about someone who's getting on in years and may need some protection, or they may not be able to handle all their day-to-day living aspects. They may not be able to make certain choices. They may not have the mental faculties or the ability to make certain decisions for them, right? And so these incapacitated adults need assistance with not only day-to-day living, but making decisions. And a guardianship proceeding, when someone files a guardianship action, they're filing a petition, what some people would refer to as a complaint, but it's in the probate division, so it's a petition. You're suggesting that somebody is not capable of handling their own affairs, that they need some assistance or some type of protection, and that they should have certain rights removed. And so you see a picture of Sumner Redstone in front of you on the screen, and there was a recent case out of California where Mr. Redstone and his daughter had a court proceeding with a former friend of Mr. Redstone's, and there were allegations that There were allegations about his competency or his incompetency, and the judge ruled that he was competent and he could take certain actions regarding who he wanted in his estate plan and who he wanted in his life and whatnot. So when we're talking about a guardianship often involves whether somebody can make their own personal decisions, like where to live, who to hang out with, whether they can vote or not, who they can vote, whether they can contract or not, right? And so a guardianship court is going to determine whether a person is incapacitated completely or fully or partially or not, and whether they can exercise these decisions or exercise these rights. And if they can't, those rights are going to be removed for them by a court. And you have an adjudicatory hearing, which is nothing more than a euphemism for a trial, right? You have a trial on that. Why? Because this is important stuff that we're talking about. We're talking about people's very personal decisions and indeed their human rights. Now, in addition to personal decisions, a guardianship may also deal with the person's money or property, right? And you've heard me talk about protection. Somebody needs protection. Well, as we age, and if we're losing capacity or becoming incompetent, even if it's a little bit, we start to let our guard down and we become vulnerable. And we can become vulnerable to prey, to people who would abuse a confidential relationship, like a friend, a family member, a loved one, even a neighbor. And so in Florida, unfortunately, we see our unfair share of elder abuse, right? Financial abuse, financial exploitation of the elderly. And so in a guardianship, one of the questions that occurs is, can this person not only exercise personal decisions, or should his or her personal rights be removed by a court and given to someone else, like a guardian? But what about property management? Can this person pay their bills? Can they manage their money? Can they pay their taxes? Or do they need a little assistance with that? My law partner, Robert Hauser, who's board certified in appellate law, recently was awarded accolades and awards for his volunteer work on behalf of the Legal Aid Society of Palm Beach County. He received the Pro Bono Legal Representation Award for Excellence. He was very successful at the Florida's 4th District Court of Appeal, representing Legal Aid Society of Palm Beach County in a guardianship matter. The appellate process for guardianship work is very, very interesting, and as I said earlier, the law is evolving on that. So if you have any questions about appealing issues regarding guardianship, feel free to give my law partner, Robert Hauser, a call. So in a guardianship, when we talk about a guardianship, and more specifically, when we talk about that, what is a guardianship? A fourth point is that an adult may need a guardianship due to Alzheimer's or dementia, right? A person's mental faculties are in decline. Their ability to comprehend or understand or remember things from the recent past, or to be able to manage money, or to understand how to take care of themselves, pay their bills, make sure they're fed, make sure they're housed properly, the bills are getting paid, and their medications are being taken. One of the most difficult things is for family members to not understand that, right? Because mom or dad may look fine. My mom suffered from dementia the last couple of years of her life. When she ended up passing, dementia was one of the causes of death. And I remember somebody saying to me, "Is your mom taking her medication?" I said, "Of course." And they said, "Well, how do you know that?" I go, "Well, mom told me that." And they just kind of looked at me and paused and smiled. And I said, "Yep, I got it." Right? We don't always know whether mom or dad are taking their medication and listening to their doctors and healthcare providers as they decline, right? As they are afflicted with dementia or Alzheimer's, because to them, they're doing everything right. But guardianship is serious business, right? We're dealing with people's human rights. We are dealing with people's civil liberties. And so guardianship courts, and I'll say this about the judges here in the probate division in Palm Beach County, do an outstanding job of bending over backwards to look out for the person who is alleged to be incompetent, right? What probate litigation law firms in Florida call the alleged incapacitated person, right? They bend over backwards to look out for and protect that person, because one, we're dealing with human rights, we're dealing with personal liberties, civil rights, and for a court to take those rights away or to restrict them is a very serious thing. The second point on that is probate court judges in Florida and guardianship courts recognize that as we age, we're susceptible to being taken advantage of by others. And so the courts and the judges really bent over backwards to make sure that the person is protected and their property is corralled and marshaled and properly accounted for. And so my law partner, Robert Hauser, who's a great trial lawyer and an appellate attorney, is getting more and more involved in guardianship matters here in Palm Beach County as well as throughout the state. So let's talk now for a few minutes about how do you file a guardianship, right? How does that happen? Well, a guardianship is a lawsuit. It's litigation, and that usually means that you hire a lawyer and you file what's called a petition. You go down to the clerk's office, you pay the filing fee, and there's typically two matters that are filed when you have a guardianship matter. One is a petition to determine incapacity. This says to the judge, I think this person is not competent or is incapacitated. I want to invoke Chapter 744, the Guardianship Code. I think someone needs protection. And then the second petition is typically one for the appointment of a guardian. If the court determines that some personal rights should be taken away, if the alleged incapacitated person is incapable of exercising some or all of his or her rights, who's going to exercise those rights? Who is going to take care of the personal decisions and maybe some of the property issues for that alleged incapacitated person, right? Serious stuff. So what is an alleged incapacitated person? Well, after you file the complaint and the two petitions, the alleged incapacitated person is the person who is believed to be in need of some assistance. It's the person who you believe is either incapacitated or incompetent, either partially or wholly, right? Well, what's that and what's a ward? Well, the ward is somebody who's adjudicated incompetent. That you've heard the term ward of the state, although we don't seem to be using that so much in the adult guardianship context in Florida. But the ward is somebody who's been adjudicated incompetent by a court of law, and they've determined that a guardianship is necessary. A guardian will be appointed, and a guardian will determine all the decisions under the supervision of the court for that particular ward. Now, a judge will issue a ruling on incapacity by removing or not removing some or all of the ward's rights. So the ward, your mom or your dad in our example, may still retain, for example, the right to determine to vote, whether they can operate a vehicle or whether they should surrender their license, who they hang out with, who they socialize with, where they live, and they may or may not be able to make determinations regarding their travel. If you're interested in learning about who may be appointed the guardian of a person, read Florida Probate Code Section 744-309. That'll tell you a lot about that and the requirements for residents in the state of Florida. I mean, many times family members want to be in control. They want to be in charge. They want to be a guardian for mom or dad. And that may or may not make sense, right? A loving, close relationship is certainly very important, and they're important factors that probate courts and guardianship courts consider when there's a petition for appointment of a guardian. But also access to your dad or mom, to the ward, is very important, right? Are you local, and are you close to mom or dad geographically such that you can provide them with assistance? Okay, a very, very big topic that we're moving on to now. Who can get involved? We're going to spend some time on this, probably about 6 to 8 minutes. And it's one of the most hotly contested, litigated issues in guardianship matters, and also increasingly at the appellate court. So why is this such an important legal topic of who can get involved? Well, family members often vie for control, right? They want to be in charge of mom or dad. They want to make those decisions for mom and dad. And if a court says that mom or dad is going to be a ward, they're incapacitated and they can't make their own decisions, and a probate judge actually removes some of those rights, who's going to exercise them? And many times family members want to be the one with that power or authority. A second reason is, increasingly in Florida, we see contested or litigated guardianship cases between a second or third spouse and adult children from a first marriage. So let's say that mom gets divorced, she remarries the tennis pro who's 20 years younger. Mom is now married to a younger man who's the tennis pro. That's her second spouse. And there's a guardianship action that's filed because mom's slipping, and somebody wants protection for mom, and they're concerned about how mom is spending her time and her money. And mom has adult children from her first marriage who are not related by blood to her current spouse, who's the younger tennis pro, right? We see that setting all the time in Palm Beach County, right? Florida, guardianship litigation matters all the time seem to involve a second or third spouse, a current spouse, and adult children from a prior relationship. Well, you need standing to participate. When we talk about who can get involved, you need legal standing. Now, what the heck does that mean? Well, before you head to the courthouse with your lawyer, you need to understand what an interested person is. And that's the magic word or the magic buzzwords or phrase. You must be an interested person to participate in the guardianship proceeding. Well, what the heck does that mean? Well, I think you'll agree that guardianship is serious stuff, right? We talked about human rights and civil liberties and about someone not being able to exercise some of their rights or to manage their property, and how a court can remove some of those rights and give them to somebody else and appoint somebody, a guardian, to exercise an alleged incapacitated person's rights. And if they are adjudged incapacitated, they become a ward. Well, this is serious stuff. And you probably agree that somebody just can't come in from Palm Beach International Airport, land, and walk into a probate court and start having a say, right? You can't walk up from the Greyhound bus station or the Tri-Rail station on Tamarin Avenue in West Palm Beach, walk into the main courthouse on North Dixie in West Palm Beach, walk up to the fourth floor, walk into a probate court, and start telling the judge what you want for somebody that you're unrelated to in a guardianship, right? Of course not. You can't do that. You have to have a stake in the matter. You have to have a nexus or some connection to the alleged incapacitated person to the Florida guardianship proceeding. So you have to ask yourselves, do you have a dog in the fight? Do you have a sufficient stake in the controversy? And if you're interested in reading more about that, you've probably heard people talk about the Hayes case, which is a Florida Supreme Court case. But more recently, the Palm Beach Appeals Court, Florida's 4th District Court of Appeal in 2015, issued the Zellman opinion, right? And the Zellman case talked all about a party to the litigation versus an interested person to a guardianship proceeding, and whether a spouse was an interested person, and due process, right? The opportunity to be heard and notice, being given notice of something, right? And if you read our Florida appellate court decisions, indeed, our Constitution is very big on notice and opportunity to be heard, right? That's our due process rights. If there's somebody out there that I'm related to or that I'm interested in, like my spouse or my parent or maybe a former spouse or a child, maybe even a more distant family member or even a neighbor, right? Who's interested in that person, and do you have the ability to participate? Are you entitled to notice of what's going on, like the filing of a petition for a guardianship, a notice of a hearing? Will you be given an opportunity to be heard? Will you be given an opportunity to participate fully in that guardianship proceeding? What I mean by that is, can you call witnesses? Can you testify? Can you make an argument before the court? Now, if you're confronted with these issues, read the Fernandez case. The Fernandez case is a 2010 case from Florida's 3rd District Court of Appeal, the guardianship of Fernandez. It's a Miami-Dade case, and it's an important case because it stands for the proposition that adversary proceedings, contested guardianships where people don't agree, should be conducted like a civil trial. Don't forget the rules of evidence, which is Chapter 90. And if you're an interested person, you get to do all this stuff, right? You're entitled to notice, and you're entitled to an opportunity to be heard, and that means you can have a trial on the matter, you can make opening and closing statements, and the right to confront witnesses and cross-examine witnesses. The Fernandez case and the Zellman case, very, very important cases for the concepts of due process in a guardianship, who can participate in a guardianship proceeding, and the extent of that participation. Very, very important cases from a procedural or a strategic standpoint. And I can tell you, literally about 4 months before the Fernandez case came out in 2010, I was in a guardianship matter in South Florida, and I was not permitted to cross-examine witnesses. I was not permitted to introduce evidence, and the judge said so much. And the reason he did that was he apparently wasn't familiar with the procedure for contested guardianships. My guess is that while he was a very good judge, he probably had never seen one of these before. And of course, I was in it because it was contested, because that's what we do. We handle disputes, trials, and appeals of wills, trusts, and estates, and contested guardianships. And then the Fernandez case came out a little too late. But so can anyone have a say in a guardianship? No, you need some connection to the person, right? You need some connection to the person that demonstrates that you have an interest in them and you have an interest in the outcome of the guardianship, right? So read the Zellman case, read the Fernandez case if you're interested in those matters. And also look for my new book, P.L.L.C's Guardianship Guide, How Your Family Will Fight Over You and Your Money While You Are Still Alive, to be released in 2017. If anybody would like a free copy of the book, you can email Amanda, AMANDA, at phflorida.com, or call her at 561-514-0900. Amanda's extension is 101. But more recently, in the first quarter of 2017, we expect that my new book, P.L.L.C's Probate Litigation Guide, will be released. You can also call Amanda if you'd like a free copy of that. Okay, let's talk about the next subject. We're going to spend about 10 minutes on that, and then we're going to hit two topics very briefly, and then we're going to start to conclude. I'm John P.L.L.C. If you just joined us, I'm a probate and guardianship litigation attorney with P.L.L.C. Hauser in downtown West Palm Beach, Florida. We handle disputes, trials, and appeals throughout the state of Florida, including contested or litigious guardianship matters. What happens when I file for guardianship? Well, you have to understand the court's role, right? The court is supposed to look out for the alleged incapacitated person. And there's a lot of things going on. The court's going to oversee everything that goes on. It's going to listen to each side, going to listen to the ward if he or she can speak and communicate. But you should know in Florida that the ward, the alleged incapacitated person, the person who's the subject of the guardianship, is not required to sit for a deposition, is not required to attend a trial, and is not even required to give testimony. Why? Because we bend over backwards to try to protect his or her interest. Court-appointed attorney. The first thing that a court's going to do when there's a petition for a guardianship is to appoint somebody to be an attorney for the alleged incapacitated person. Why? We need somebody who's objective and independent looking out for this person and to make determinations about this person, including whether they're incompetent or not, whether they want to fight the petition or not, and whether they need protection or not. The court is also going to appoint an examining committee. Right, the examining committee consists of three persons. One of them may be a medical doctor. The other two will probably be health professionals who have some involvement with either the senior population, the elderly, or mental matters, right? The psychological or psychiatry matters. And the examining committee is actually going to go out, meet with the ward, the alleged incapacitated person, and complete a report and tell the judge in a written form, tell everybody else who's interested in the guardianship what they discovered and what their opinion is. And they'll make a very specific opinion after they interview the alleged incapacitated person, the person who's the subject of the guardianship matter. They'll determine whether they think the person is incapacitated, partially or wholly, or not incapacitated. And if they make the determination that somebody is partially or wholly incapacitated, they'll recommend what rights should be removed from that person. In other words, they're going to make a specific recommendation as to what this judge should do. Judge, you should remove the following rights from this person. Don't let this person exercise these rights. It might be the right to vote, to manage money, to pay taxes, to travel, to drive, to cohabitate with someone, to determine what their living conditions or where they live, or who they socialize with. Now, those examining committee reports will be filed with the guardianship court. But remember, from a procedural standpoint, if you're involved in a contested guardianship, that those documents are hearsay documents, right? They're out-of-court statements offered for the truth of the matter asserted. And if you go to the adjudicatory hearing, the trial, the the hearing, the evidentiary hearing on the guardianship petition, unless you have the examining committee members there, or unless counsel for the parties stipulate, those committee reports are inadmissible hearsay upon a proper objection in a contested guardianship. You can read the Shen v. Parks case to tell you a little bit more about that issue. So what does that mean? Well, it means your trial lawyer has to get around that expected hearsay objection if they want to get those reports into evidence. But a probate lawyer or guardianship lawyer, an elder law lawyer in Florida, should not make the assumption that just because a guardianship court appointed this examining committee, that those written reports get into evidence, right? And at the end of the day, the judge needs evidence. And there's all these appellate court decisions about the evidence from this adjudicatory hearing, the evidence from this guardianship trial, or the evidence from this petition. You've got to move documents into evidence, right? Because the judge needs evidence, testimony, documents that are properly before the court to make findings of fact and to apply the law. So be mindful when you're in court about those examining committee reports. And if you don't like the examining committee reports in your litigation strategies to suppress them, know how you may or may not be able to suppress them. Another part about reports is you'll get an annual report from the guardian on an annual basis, right? The guardian has to file all these documents and file these annual reports. So if a guardian is appointed and you're beyond the petition for to determine incapacity of the petition for appointment of a guardian, you get to read the annual reports, but be careful. You can object to them, but you've got 30 days to do that. And you can read Florida Statute 744.367 and Florida Guardianship Statute 744.369, as well as the Rothman-Browning case. And the citation for that is on the screen. And those statutes and that case speaks a little bit more to those objections when you see a guardianship report. Remember now, the law for guardians and guardianships does not protect those who sit on their rights, right? The law rewards those who exercise their rights, goes to court, files documents, makes objections, and seeks an opportunity to be heard. Silence is often inferred as acquiescence, and in the objection to an annual report topic, you only have 30 days to do that. What about a power of attorney or a trustee? You absolutely need to know if there's a power of attorney for the ward, the alleged incapacitated person, or whether they have a revocable trust. And the reason for that is that one of the things that a court is required to consider is whether there's an alternative to a guardianship. Does the alleged incapacitated person, the person who's the subject of the Florida guardianship, have an estate plan in place such that there's an alternative to a guardianship that adequately addresses his or her needs? And those are the key buzzwords from the Florida statute. Is there an alternative to guardianship, a lesser restrictive alternative which adequately addresses the needs of the ward, right? And so if a person has a revocable trust and a power of attorney, you may not need a guardianship because that person already made a decision about who he or she wants to make decisions for her or him and who's going to manage their property if they're not competent, right? Because a POA, a durable power of attorney, is effective during incapacity or disability, and a trust, a revocable trust or a living trust in Florida, is typically always operable even when somebody becomes incapacitated. Indeed, Florida estate planning attorneys often prepare healthcare documents, trusts, and powers of attorney for that very specific purpose, right? It's not only going to assist you day to day, but if you become incapacitated. So if there's a revocable trust out there, it's common practice in Florida to use a power of attorney to gather the ward's assets, safeguard them, marshal them, get them, account for them, and give them to the trustee to manage. Why? Because that's what the ward wanted, right? He named a trustee or a successor trustee to his revocable trust or his living trust. He signed a power of attorney giving specific authority to somebody to complete acts on that person's behalf. Just be mindful, if there's a trustee out there, they may or may not be subject to jurisdiction in the guardianship proceeding. whether they do or don't file an appearance, whether they do or don't have a lawyer who participates in the guardianship proceeding. If you're trying to work with the guardian's trustee, your probate litigation lawyer needs to know whether the court has jurisdiction over that trustee, particularly if they're a non-resident of Florida, if they're outside the state of Florida. And you should also know whether they consented to or assented to jurisdiction. And the case cited in the prior screen will give you some overview. The Sowden case, S-O-W-D-E-N. But here's one of the hot topics in guardianship litigation in Florida. Can you thwart an estate plan? Right? Read those statutes. Read those cases that are mentioned in your slide. This is increasingly contested in Florida probate courts. Can somebody file a verified statement saying that an estate plan of the ward is invalid because it was either signed at a time when he or she didn't have the requisite mental capacity or was the product of undue influence? And can a probate court or a guardianship court ignore that estate plan based on that verified statement and say there is no lesser restrictive alternative, I need a guardian, and in essence ignore the estate plan? Now, the court in this Searle v. Bent case, a Florida 2nd District Court of Appeal guardianship case from 2013, draws an important distinction between saying, I'm not going to consider those documents, that estate plan based on this verified statement under Florida guardianship law 744.331 versus declaring those estate planning documents invalid, right? They draw a distinction between saying I'm not going to consider them versus they're not valid. There would be a separate proceeding to determine whether that estate plan is valid or not, and we can argue about whether that should even occur in a guardianship proceeding. Although the guardianship code in Florida does permit a probate court judge to alter an estate plan. Healthcare documents, you've heard of such things as living wills, healthcare proxies, and whatnot, durable healthcare powers of attorney. If those documents are in place, do you really need a guardian to exercise those rights? Probably not. You should probably let the person who's designated in those healthcare documents make those healthcare decisions for the alleged incapacitated person. Another hot topic in Florida guardianship lawsuits and litigation is, what about divorce? There are restrictions or perceived restrictions both in Florida statutory law and case law about whether somebody can get divorced after a petition for guardianship has been filed, right? Can you get divorced if that petition has been filed? Can you get divorced if a guardian has been appointed or somebody has been determined to be incompetent? There's a 3-year window on that. Trial attorneys and judges have struggled with this, and they have found ways to get around it when it's in the ward's best interest after the proper due process, which includes notice and an opportunity to be heard. Now, as we're concluding, I'm going to talk to you about the X factor, right? Attorney's fees. And if you've listened to my other webinars or read some of my commentary or seen me speak, you know that I refer to attorney's fees in the probate litigation context, including guardianship cases in Florida, as the X factor. Why? Because litigation fees are expensive, right? Not just if you're litigating probate matters, but if you're litigating anything in Florida and in court, right? Because you have to prepare documents and you have hearings and you have to lay down a record for appellate purposes. That means you have to file documents and you're drafting them and reviewing them and conducting research. And not everybody agrees with what you write. So there's hearings and you have to go to court. You have to prepare for court. And if there are evidentiary hearings, you have to prepare witnesses and call witnesses and prepare documents and introduce documents. And you need someone to lay a foundation, and you get the point, right? Legal bills can be very, very expensive. And so when you're involved in a guardianship litigation, you should not assume that you're going to get your attorney's fees paid from your mom or your dad's trust or their revocable trust or from their checking account or their bank account. Discuss the issue of attorney's fees with your Florida probate litigation law firm and your Florida elder law attorney or your Florida guardianship lawyer. What if there is a power of attorney? We kind of hinted at this a little earlier. A power of attorney should absolutely be considered when a petition for appointment of guardian is is considered by a probate court, you want to determine if, one, there is a power of attorney out there, two, if it's valid, and three, who has the original. Right? Very, very important evidentiary and procedural issues that are sometimes overlooked. But if a power of attorney exists and it's valid, then that can certainly be a lesser restrictive alternative to a guardianship which adequately addresses the needs of the ward. Be mindful that there is a relatively new Chapter 709 power of attorney law in Florida, and you should be mindful of that. And you should be particularly mindful of the Florida power of attorney, so-called superpowers, that can permit an attorney in fact or a power of attorney to change beneficiaries or alter an estate plan. So in conclusion, I want to thank you for listening to P.L.C. Hauser's live webinar on Florida guardianships, what you need to know about adult guardianships in Florida, and invite you to call me or my law partner, Robert Hauser, if you have any trial or appellate issues you'd like to discuss. I also encourage you to listen to our future webinars, including 2 seminars on ethics in Florida that'll be eligible for CLE credits if you're a Florida bar member. My name is John P.L.C. I'm a probate litigation attorney with P.L.C. Hauser in downtown West Palm Beach. And this concludes my remarks on Florida guardianship matters. Thank you for listening.